Yesterday, the Fourth Circuit Court of Appeals took up the case of whether or not Madison Cawthorn can in fact end up on the ballot, which, as we all know, is about a week too late because Madison Cawthorn already lost his primary, so it doesn't matter if he's even allowed to be on the ballot. But the decision, by the way, from this court is actually pretty big and could have ramifications that stretch far beyond the borders of North Carolina. And the reason is because of the legal argument that Cawthorn and his lawyers put forward. See, Cawthorn and his lawyers had gone into court arguing that the 1872 Amnesty Act removed the provisions from the 14th Amendment that says that anybody who engaged in or supported insurrection barred from public office the rest of their lives, blah, blah, blah. They said the 1872 Amnesty Act cleared all that up. So Madison Cawthorn, even if he did aid the insurrectionists in any way, which they still claim he didn't, even if he did, he's not barred from office. And the appeals court said, actually, that's not true. Because the appeals court officially ruled that that 1872 Amnesty Act only applied to individuals that engaged in insurrection prior to the passage of the 14th Amendment. And last time we checked, everybody that would apply to died long ago. So yes, the court says, the 14th Amendment does in fact bar people who engaged in an insurrection from ever holding public office again. The Amnesty Act only applied to people who fought in the Civil War and later wanted to run for office, which was prior to the passage of the 14th Amendment. That's a big deal, because it does mean that in the future, I mean, hell, why am I even saying in the future? We have people who participated in the Capitol riot running for office today. Today! And I'm not talking about, the tenuous relationships like Marjorie Taylor Greene and her tweets and Madison Cawthorn and his tweets and actions, or even Hawley with his fist pump. I'm talking about actual people who were there and stormed the Capitol running for office. They engaged in insurrection. And this court is telling us they need to be barred from holding public office for the rest of their existence. That's powerful. That is obviously something that everybody else needs to pay attention to. If you live in an area where an individual is running for office and we know that they participated in the Capitol riot, I suggest you immediately file a 14th Amendment challenge to their candidacy and get them kicked off the ballot and off of every ballot for the rest of their lives. That is the green light that court just gave us. Now, the only caveat could, of course, be, what is an insurrection? Now, I know it seems pretty obvious, right? We could define it, sure. Could you define it and convince a court that that is in fact what happened and that somebody took part in it? That's a little more difficult, isn't it? And I hope people understand that. Just because we saw them at the Capitol riot, if a court doesn't view that as an actual insurrection, the 14th Amendment would not in fact apply to this person. So, it's a tricky road. We've got a roadmap though. We know how to navigate it. But at that point, it's just going to depend on what kind of judge you get and whether or not they define what happened on January 6th as an actual insurrection. This is Hattie. Hattie wants to know why you have not subscribed to our channel. You obviously like our videos, so do us a favor and subscribe.